Good afternoon, everyone, and Happy New Year. My name is Tripp VanderWal. I will be hosting you through this edition of the Benefits Lunch Break webinar series. Before we get started, a few housekeeping items before I get started on the substantive issues, a couple housekeeping items. As we announced in our December webinar, we are going to continue this employee lunch break webinar series into 2024 with slight modifications. We're only going to have scheduled dates every other month rather than every month. So again, nothing else has changed. It'll still be on the third Wednesday of each month at noon, but it'll be every other month. And just in case you are worried about the decrease in amount of webinars, to the extent that we have any uh, immediate items or hot pressing issues come up, we will schedule additional webinars to address those, and we'll use this mailing list to alert folks of those kind of periodic webinars. So again, we're going to only have 6 scheduled webinars for 2024, but as need be, we will have more. So we're not going to leave you hanging or make you wait an extended period of time for some issue that is pressing. As always, if you have certain ideas in the benefits spectr that you would like us to address, please let us know. We certainly have a number of issues that we always want to bring to your attention, but sometimes, you know, if there is a particular subject or issue that is acutely popular, we may sub that in and address that. And just to note, you know, this is a benefits lunch break series. Sometimes we bring in some of our employment law colleagues to help us with these webinars, but any suggestions should be really focused on benefit issues than they are employment issues. You can either give us these ideas through the post webinar survey, excuse me, or even in the question and answer feature. With that, and we'll get started. Good segue. I will be taking questions. You can see the question and answer feature. I'll be monitoring those. To the extent that I can, I will address those as they come in. However, if I think I'm going to touch on the question, I may put that off. And then we will try to end here. I hopefully we can keep this presentation within a half hour. I know folks are busy. But we will try to leave some time at the end of the webinar for additional questions. So with that, let's get started. Today, we're going to be looking at an outlook on issues that will impact group health plans in 2024. I've identified certain issues, four issues that I think are on the horizon for health plans. The first has to do with Department of Labor health plan audits. As we'll talk about in a minute, I see these increasing, not decreasing. Historically, at least in the past 12 years or so that I've been doing this, Department of Labor audits of health plans have been few and far between, if any. That has changed in the last couple of years, and I see that increasing rather than decreasing. Second, we'll talk about the future of these prescription or RX accumulator programs. I know a lot of folks use this. Popular companies, Savon, SP, Pillar RX, Matrix, Payer, LLC. There's a whole host of them that are out there these days. I think Savon is probably still the most popular only because that was, I think, they were the first to get into this. But there's been a lot of litigation surrounding that we'll talk about that may potentially, I think, certainly change the way these programs operate in the future, if not make them much less valuable. Next, regulatory activity. What regulatory activity do I expect in 2024? Specifically with respect to the fact that we have a presidential election this year, and potential changes and certainly changes in administrations can have a significant impact on regulatory activity. Finally, HIPAA. We haven't talked about HIPAA, I guess, thank goodness for most of you folks, in a while, but there are some HIPAA changes on the horizon that we are closely monitoring. There has been for the last couple of years. that I think may gain some traction this year, especially in light of last year's Supreme Court decision overturning Roe versus Wade. With that, we'll start with the Department of Labor audits. So, as I mentioned in the introduction, historically, Department of Labor audit activity in the health plan sphere has been minimal, if at all. However, beginning in 2022, I've had two larger clients that have had a general, not target or not issue specific health plan of their or audit of their health plan. So that trend is changing, and uh, I don't see that decreasing in the future. I feel actually that will be increasing in the future. Why do I think that is, the ACA is, I think it's hard to say that that's new anymore since it's over 10 years old. But there still are ACA protections that are kind of slowly rolling out, or regulatory activity and how those are implemented are coming out. And then also this Consolidated Appropriations Act in 2021, which you've heard me talk about a number of times, passed in the evening on December 27th of 2020. And that legislation probably had the most significant impact on group health plans since the ACA. Uh, because of these changes or impacts on health plans, uh, the Department of Labor has an increasing interest in making sure that health plans are complying with those requirements, which I think is going to lead to an uptake of audit activity. Also, the Department of Labor has informally indicated at different seminars I've been at with DOL representatives that 25% of their investigators are now being specifically trained and dedicated to compliance issues with respect to group health plans, particularly with respect to compliance with the Mental Health Parity and Addiction Equity Act. As you know, if you've listened to any of these webinars, mental health parity has been a focus. I mean, if you can connect the line dots from one administration to the other back from 2008 and even maybe before, as the administrations have changed from Republican to Democrat, back to Republican, back to Democrat, the one kind of underlying consistency is the administration's commitment towards addressing mental health parity and addiction equity act. Certainly, that was only heightened by the repercussions of COVID and lockdowns and whatnot. So I don't see Department of Labor audits decreasing in the future. I see them increasing, which is a good reason now to take stock of, hey, what issues, let's go through our health plan. Maybe let's do a self audit. Maybe let's bring in a consultant, bring in an attorney, look at that so we can identify these. You know, prevention is certainly the best medicine here in trying to identify issues before, internally before they're identified by the Department of Labor. Audits can really be the result of a number of things. I think participant complaints is probably the most common. So, as most of you know, if you look at your SPDs in the back where it has a statement of participant rights, there's information that participants can use to call the department's Department of Labor's EBSA division. EBSA is the acronym for the Employee Benefits Security Administration. That is the subset of the Department of Labor that has jurisdiction to ensure that benefit plans, both retirement and health plans subject to ERISA, comply with all those requirements. There can be national projects. The good example of this is compliance with Mental Health Parity and the Addiction Equity Act that generate a lot of audit activity. So we're going to see a lot of that with mental health parity. Review of compilation of data contained on Forms 5500 and other reporting forms. So if they see issues that are identified in the Form 5500, that may trigger an audit. I think that's a little bit more common on the retirement side, only because most retirement plans have to be, the 5500 has to be filed along with audited financial statements. And so they're a little bit more useful, I think, to the department than the Form 5500s for health plans. But again, information contained on the 5500 can be the basis for the Department of Labor initiating an audit. Also, the Department of Labor does not have its head buried in the sand. They may get referrals from other agencies whether that be HHS, Internal Revenue Service. So if the IRS, which kind of has concurrent jurisdiction over benefit plans, comes in and does some type of audit, tax audit that implicates an employer health plan, and they see issues that uh, may be violations of ERISA but don't fall in their jurisdiction, they are well within their right to notify the Department of Labor. So the kind of, it's like when it rains, it pours. You finish up an IRS audit and you suddenly get a Department of Labor audit, or vice versa. And they can also, gather information from news, television, industry journals in order to initiate audits. Audits can be random, but again, the Department of Labor, maybe not as much as the IRS, has limited resources. And so I think that's the random audits are more rare, but it's certainly possible. Keep in mind that discrete issues may be resolved quickly by a call from a DOL benefit advisor. I think a good example of this, and that's why it's if you get one of these calls and you don't want to handle it yourself, talk to your attorney, give me a call. We can help you walk through this. Be proactive about it, and then we can get this taken care of right away. A good example of this, as most of you probably know, during the COVID outbreak period, we have all these benefit extensions. Kind of the biggest lift here, the biggest admin issue was with respect to COBRA. You allowed participants an excessive amount of time to elect COBRA, to pay for COBRA, for notices to go out. I had one client that sent out those special COBRA notices to folks that had previously not elected COBRA, and it opened up that window again as long as they did it. They did not, this client failed to identify one person that was eligible to receive this notice and open that window. The person was aware of this. They called EBSA to complain. EBSA then called the client or contacted the client, which came over to me. And I talked to the DOL benefit advisor. We figured out the facts and we determined, hey, yeah, this person should have gotten this notice. They should have been allowed to enroll in that special window. I worked with the client. We worked with their TPA for their health plan, got everything squared away. Individual sent the notice. We followed up with the DOL benefit advisor. They ended up following up with the individual who made the complaint. It was all taken care of in a matter of 2 weeks and maybe 3 phone calls. So those are the good, those are the issues that if you have to deal with the Department of Labor, those are much better, because if you actually have an audit or an investigation, they can take years. By way of example, the 2 audits that I mentioned that I have clients going through started in February. They got their initial letter in either late January or February of 2022. So we are working on 2 years of this audit process, and I'm not so sure that I see an end. I mean, there's an end in sight, but I don't know if I see it yet. So if this went on for another year, I would not be surprised. I mean, I'm hopeful, I'm optimistic that we will resolve this year, but I certainly wouldn't be shocked if this rolled into 2025. So how do DOL audits and investigations go? It's going to start with a letter from the Department of Labor, and it's typically going to be addressed to the address that's on the 5500 and addressed to the individual who signed the 5500. This letter is going to it's very authoritative. It's going to set forth the Department of Labor's jurisdiction over health plans and why they have the legal ability to conduct this audit. And whatnot. And then it's going to have, most importantly, a document request list. And this list is, especially if it's a full scope health plan audit, not targeted on a specific issue, is going to have a number of items requested. And this is the time when you get this letter to contact legal counsel, involve legal counsel, not at the end when you get the conclusion letter and we have to work from there. Having legal counsel review all of the documents before they're submitted to DOL is a great idea, so that we can start identifying any issues to the extent you haven't done a self-audit already. And we can actually get the fixes in place as the audit's going on, so that if the DOL comes back and says, we identified this issue, you can say, hey, you know what? We identified that issue. We've already corrected it, or in the process of correcting it. Here's what we're doing. That's great. That's going to establish a great relationship with the DOL. Keep this much more in line with the DOL just assisting with compliance versus their attitude towards enforcing and penalties. And frankly, that's the good news. Is that the Department of Labor audits typically focus on trying to increase compliance with the various regulatory statutory requirements. They don't generally take the position, as long as you're working with them, that they want to penalize you, enforce penalties, engage in some lengthy litigation. So again, if you get this letter, involve legal counsel, be proactive. As a side note, if you do have fiduciary liability insurance, it may be um, uh, you may want to let them know, not only to get the claim process started. Generally, there's a notice requirement in order for the liability to provide any coverage, and it may cover your legal fees. Again, up to the maximum amount. The requested documents, as I mentioned, can be overwhelming, but again, as long as you're proactive, we can, what I found is a very workable schedule is to say, hey, we're going to have kind of this rolling production schedule. So within 2 weeks from now, we're going to give you these documents. Within 4 weeks from now, we'll try to give you these documents. And within a month from now, we'll give you these documents. The amount of documents that you're going to give in a general audit are so big. The Department of Labor is okay with that because they are going to have to take a significant period of time to review it anyway. But the idea is to be proactive, be in contact with the Department of Labor. Otherwise, if you just ignore it and you miss the deadline, they're not going to be so willing to extend it. Now, keep in mind, if you have a targeted or an issue specific audit, especially in mental health parity, if they ask for that NQTL comparative analysis, there are specific statutory timelines that apply and with you responding and giving that NQTL analysis. The Department of Labor in the first year that these NQTLs were required in 2021, and even I would say 2022, were somewhat flexible in the time that those had to be provided. But they have indicated informally that now this has been around long enough, at least in their opinion, that they are going to be much less likely to extend deadlines to turn over the requested information. I did get a question that says, what are the size of the audited clients? My clients are both quite large. And they both have self-funded plans. So again, I think if you're self-funding, you're more likely to see an audit because if you're fully insured, either the Department of Labor or the state insurance regulatory agency is going to have jurisdiction over the insurer, and they're probably going to initiate audits with the insurer rather than the client. Now, keep in mind, if there's COBRA issues, that's more on the client, even in the fully insured plan. But the larger you are, I think the more likely that you are to incur an audit. Not that you're going to, but that I think there is probably correlation between likelihood of an audit and size by employee, by number of employee. But that doesn't mean that if you're a small employer and a participant calls with a complaint, a viable complaint, just because you're small in size, have a fully insured plan is not going to necessarily protect you. Moving on. So many of keep in mind that many of the documents that are requested are probably not even in the health plan's possession. I will tell you, and I'm going to stress this multiple times. You'll see this on another slide. The first and second items that are always requested are the plan documents and the SPDs. So make sure that you have a plan document and an SPD for your health plan. Whether that be a single document, how we generally prepare them, or they be a separate document. And remember, that generally consists of certificates of coverage, benefit summaries from your carriers and TPAs. Make sure you have those and that they are up to date. If you don't, you are starting in a bad position with the Department of Labor. They are going to start looking into everything. Those are pretty, what maybe you'll call as blocking and tackling. They're basic requirements. So make sure you have that plan, make sure you have that SPD, make sure you have the underlying documents, and make sure they are up to date. Otherwise, that's going to kind of set the tone of the audit. And I've not seen a full-scale audit where they have not requested those documents. Um, so other documents may be in the possession, as I said, of third parties. If especially with respect to a self-funded plan, they're probably going to request a fair amount of claims information. That hopefully is not in your possession; it's in your TPA's possession. And so if you're going to have to turn over third-party information to the DOL, I think you have to think about how you want to do this mechanically. Do you want to have the third party send it over straight to the Department of Labor? And to the extent that you have claims information, that may make a lot of sense because as an employer, you don't need that information. You don't want that information. It just sets you up for potential for further breaches, which then becomes a HIP issue. So you may want to have the third party send it straight to the Department of Labor, which is generally a possibility. Alternatively, do you want a third party to send it so it still stays out of your position? So a business associate. Do you want your attorney? Again, if you're going to have your attorney review all this information before it's submitted to the Department of Labor, which is not a bad idea, or an insurance broker, that's generally permissible and acceptable to the DOL as well. Just make sure that if you do that before you turn over that information, or before that information, the proper BAAs are in place with those business associates. The way you turn over this to the DOL is generally going to be electronically. I think they will take paper, but probably they're going to say, hey, if it's in paper format, will you scan it and send it electronically? The department has its own, secure electronic file exchange that they like to use. However, if you have your own third party or your own third party secure exchange, um, and you want to use that, they're generally willing to do that too. They usually have to get sign off from the manager. But for example, one of my clients, we used Miller Johnson's secure file exchange because I could tell when the DOL was accessing those documents, I'd get a notification. So that was helpful. I could kind of monitor his progress. Now, that ended up not being as helpful as I hoped because what they did is opened it and immediately downloaded it to their system. So they were doing it quite fast rather than just accessing it out of the system. But again, that may give you a little bit of window into what they are reviewing. Um, Keep in mind that even though that the initial document requests will be overwhelming in many ways, it's probably not the end of it. So as you go on, they will have follow-up requests, whether that be because they've reviewed stuff and there's something missing, or whether they've reviewed stuff and there's mistakes and they want justifications, whether they reviewed stuff and they don't understand it, whether they've reviewed stuff and they found, just be prepared that this is an ongoing iterative process. I got another question that says, a non-federal government plan less likely or more likely to be audited? I don't know that. I don't have a crystal ball, and I'm not sure. I would say anecdotally, it's less likely. So if you're a non-federal governmental plan, you're not subject to ERISA. Now, you're still subject to a lot of the same requirements under the Public Health Service Act. And there's no exemption from the ACA. There's no exemption from the Consolidated Appropriations Act. Technically, you're not subject to COBRA, but you're subject to the exact same continuation provisions under the Public Health Service Act. The one key difference is you're no longer in Department of Labor jurisdiction. You're in HHS and again, state insurance regulatory jurisdiction, depending on whether you're self-funded, fully insured. So I don't have exact stats here for you, but I would say if you're non-federal governmental plan, at least at this point, audit activity is still, I think, of health plans is lower. So as the DOL audit progresses, it will move from just document production into interviews of individuals who have knowledge of the plan. And now keep in mind, this may be these interviews are going to start off, and so again, before you have an interview, I hope you've involved your attorney because they're going to want to sit down with the people who interview and prep them, just like you would prep someone for a deposition. And I use that time not only to prep, but to say, hey, I want you to be aware that the Department of Labor at least starts these process live, and they're pretty pretty formal. Like, if they're in person, which is not always the case, sometimes they'll occur virtually or telephone. But one of my clients had virtual interviews. The other client, the actual DOL agents came to their location. If they're in person, they will pull out their badges to show you. They'll also say that we're conducting this official investigation on behalf of EBSA, and to the extent we find anything that violates laws, that we will refer those to the appropriate agencies, including the Department of Justice. So as my former partner, Jim Brunsma, used to say, there's no such thing as a ERISA jail. And if you steal from benefit plans, you just go to normal jail. So again, these interviews are generally, once they get started, pretty informal. It's not like the DOL auditors are looking for a, hey, gotcha, or trying to slip you up like some sneaky courtroom lawyer that you watch on courtroom dramas on TV. What they are really trying to do is understand how the plan works better. And so these interviews are likely to include employees of the plan sponsor, particularly those who are most familiar with the plan. But it's also likely to include third parties. So if you have a TPA, and frankly, you're going to have to work both with your TPA with the DOL to schedule this. And often with the TPA, they'll say specifically if it's a bigger one, okay, well, these questions kind of fall in this person's expertise or area. These questions, so they may not be able to put up one person that can answer all these questions. It may have to be a host of interviews or a larger people join it. And keep in mind, the TPA is likely going to want to have their attorney on the line as well. So this becomes kind of a party, which is why I think when you start having interviews of third parties, they're much more likely to happen virtually or telephone, just for logistic simplicity. Again, so keep in mind, it may be virtual, it may be in person. And I will tell you that my in-person interview happened in late September. And that was because the government's fiscal year runs from October 1 till September 30. And the DOL interviewers or auditors were pretty forthright with us and said, we have a travel budget that expires at the end of September, and we had to use up that travel budget. So we decided to come up from Cincinnati to come up to Michigan. So there may be that. So the reason I say that is just because they come on site does not mean that they have any inclining that there's something nefarious going on. So take that for a grain of salt. It could be they're just trying to justify their expense budget. Okay, moving on here. All right, so how does this wrap up? So, you will likely be notified by a letter from the Department of Labor of its conclusions. And remember, the Department of Labor has to justify its own budget, so they're likely going to find something wrong. Hopefully, it's just minor issues, but again, at least they can go back to their superiors and say, we found something. How you respond. You can agree with this, implement the corrections, pay any fines. Again, I think fines are generally only going to occur in areas of significant gross negligence, malfeasance, or criminal activity. So it's very rare. I don't necessarily recommend that idea. I think the most idea is to say, have your lawyer respond to that letter and say, we don't agree that we have violated any sections of ERISA. Having said that, well, blah, 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 we are, in effort to move this along, satisfy you with this, we will voluntarily make these corrections or these changes prospectively. And there may be some going back from between the Department of Labor, but finally you'll hopefully get, and I think you're optimistic, you're likely to get to a point where you agree upon this. The Department of Labor will send you a compliance statement or compliance letter that says, here's what you're going to do based on our understanding. And they'll probably say, we're going to review, we're going to check in, once or twice a year for the next 3 years, for example, to make sure that you are actually honoring your commitments. Again, it won't be a full-scale audit. It'll probably be a phone call, maybe some minor document requests, but certainly nothing like you've just went through. Now, if you disagree and you don't do anything or you just don't respond, the DOL will refer it to its Solicitor General, at which point it's up to the Solicitor General to take legal action. And that means basically filing a lawsuit against you in federal court. Then we're off to the races. And I think, if anything, at all possible, we want to avoid that outcome. So again, prospectively work with the Department of Labor auditor, timely acknowledge your request, involve legal counsel, make sure your SPDs and plan documents are up to date. We have enough legal changes, and that, frankly, my clients tinker with their health plans enough from year to year that this is probably something that should be reviewed every single year. The SPD should be reviewed every single year. That doesn't mean we need to do a full restatement, but unfortunately, you don't have, in the retirement plan world, if you're on a pre-approved plan where you really only have to look at a full restatement every 6 years, since tinkering is all, even if there's no legal changes, there's always tinkering with health plans. We moved this carrier, we changed this eligibility requirement, we eliminated this benefit, we added this benefit. We need to make sure the SPDs are up to date. So happy, give me a call. We can certainly look at your SPD. We can give you a pretty good quote on what we think it'll be able to update it. But again, blocking and tackling, make sure your SPDs are up to date. With that, the hot audit litigation top minutes again. So there you go. Plan documents, SPD. Make sure your SPD is updated. Mental health parity, still a huge thing. NQTL, comparative analysis. We're going to see more requests for these, not fewer. I know that your TPAs are still reluctant to give these, and the ones that they give, I think, are largely not going to satisfy the DOL's expectations. Having said that, TPAs are getting better. One large TPA provided my client with and again, if you're self-funded, their comparative analysis is never going to be based on your plan. It is going to be based on the underwritten plan, their fully insured plan, for which your self-funded plan is based. And then, to the extent that you've made any benefit design changes on your own, if that impacts NQTLs, you're on your own to supplement that analysis, for why that is still compliant with the Mental Health Parity and Addiction Equity Act. So keep that in mind. I have one large TPA that, with another large client, did give theirs, and trust me, it is much more. I think it follows the DOL format. I think it's much better. I don't know that it's there, but to give you an idea, it is, the NQTL analysis is in a binder, and it's 3 inches thick. So if you get an NQTL analysis from your TPA, and it's 3 pages, and it just references this medical policy or this internal policy, that's not going to be sufficient. And it may even be viewed as the DOL as a non-response. The other issue that's hot right now is APA therapy. And the thought, I think, on this has changed even in the past 5 years. Bottom of the line, I don't think exclusions of ABA therapy are permissible anymore under the Mental Health Parity. I have my own qualms about that with respect to how courts and the DOL have interpreted this. But if you do exclude ABA therapy, I think you are in a risky area. I think you are increasing your likelihood of both litigation and DOL audits. And with the likelihood of either of those being, you're going to have to reprocess denied ABA therapy claims, pay them. And since they're paid after the fact, if you're self-funded, they're not likely to be covered by stop loss. You may still be able to impose some limitations on ABA therapy, but again, we have to be careful of those to make sure that they're comparative with any type of NQTLs imposed on medical surgical benefits in the same classification. Which, as folks know, is not an apples to apples comparison. Wilderness therapy. This is another issue that has seen a lot of change. I think, even again, 3, 4, 5 years ago, wilderness therapy exclusions were not only common, they were universal, pretty much not challenged. I think the IRS would even taken the position that didn't constitute medical care, so couldn't be provided on a tax-free basis. I think the thinking of all of that is changing. There's been a lot of litigation that denied wilderness therapy treatment is a violation of the Mental Health Parity Addiction Equity Act. Um, for some reason, a lot of this litigation takes place in Utah. I think that's likely because there seems to be a lot of active plaintiffs' attorneys in Utah. And I think, frankly, Utah is an area where a lot of wilderness therapy uh, centers or programs exist. And it's typically the wilderness therapy center, not the participant that's bringing the claim on the participant's behalf. Lastly, transgender benefit exclusions. This is, we're shifting in the wind. First we can exclude, then we can't, then we can exclude. So there's, based on the regulations issued under the Affordable Care Act, Section 1557, for those of you that have been paying attention over the last years, you're familiar with this. It's going back and forth, back and forth. But keep in mind that there is a number of courts out there that have said we don't need HHS's regulations on 1557. We can interpret from the statute that denial of these benefits are a violation of 1557. And I think that's just the trend we're going. And frankly, now I think much more of my plans do not have any blanket exclusions from transgender benefit exclusions, which is good. It's gonna, at least from a compliance perspective and avoiding litigation in the future. But now we're getting into specific, I think, procedures. One that's come up a lot lately, facial feminization surgery, FFS. I think another one that sounds a little bit painful to me is throat scraping. Those have been denied as cosmetic, and people are challenging those as not being cosmetic, as truly being medically necessary for individuals who are aligning, have gender identity disorder. So keep in mind, those are kind of the hot both audit issues and litigation issues going on right now. With that, let's kind of shift gears here to the future of our prescription drug accumulator programs. Just a quick background. I think most of you on the plan are on the webinar, at least are aware of these. If not, your program utilizes them. Again, Save on SP is probably the most popular one. It's by no means the only one. What happens is you hire a third party, generally through your PBM. That third party service provider, once someone fills a prescription that's on the program's list, which are generally high cost prescription, the third party reaches out to that person and says, hey, we have this program that can save you money. Are you willing to participate? And if they're not willing to participate, generally the penalty is the participant's copay is significantly increased for that drug. Now, if the individual agrees to participate, their coinsurance is significantly reduced, many times to no copayment at all. And this is true even if the participant doesn't qualify for the underlying participant drug manufacturers or the drug manufacturer's copay assistance program. So if the individual agrees to participate in this program, the third party assists them in enrolling in the drug manufacturer's copayment program. And what happens is that the third party tracks the copay assistant received, and then they're able to exclude that amount from a participant's deductible and out-of-pocket maximum calculations. So essentially what this does is it shifts the financial benefit of the manufacturer's copay assistance from the participant to the plan. And so, for example, let's say my out-of-pocket maximum under my plan is $12,000. And let's say that I have a prescription that costs $2,000 a month. Without the copay assistance program, I'm going to hit that $12,000 in 10 months, which means any other expenses that I incur in those last 2 months are going to be paid 100% by the plan because I've hit my out-of-pocket maximum just on my prescription. With a copay accumulator program, I don't necessarily have any out of pocket that's coming out of my actual pocket, my wallet. All of the out of pocket's being paid by the manufacturer's assistance, but it's not going against my out of pocket maximum. So if I incur other expenses under the plan, I am still going to be subject to either to the deductible, copay, or coinsurance requirements until I otherwise hit the out of pocket maximum. So that's how these programs work. That's how they save plans money. There has been significant litigation in this area. The first, J&J versus Save on SP. The second, AbbVie versus Payer Matrix LLC. Both of this litigation is in its early stages. Right now, I get notifications almost every day on different documents being filed with the court. It's all about, they're in discovery mode, and it's all these motions about trying to redact or seal different discovery that's being produced because it's highly sensitive information. But the basis of these two lawsuits is these programs, Save on SP or Payer Matrix, are encouraging, assisting, facilitating individuals into fraudulently applying for these copay assistance programs. In fact, J&J, for at least two drugs, and I'm not sure why they haven't done this for all, on the terms and conditions, they basically say, in order to be eligible for this program, you have to certify that you are not eligible for a copay accumulator program. And so the basis is they're getting, like, J&J is suing Savon, for example, for intentional interfere with contract, you know, and you know, encouraging fraud and trying. So I don't, you know, and I'll talk about the third case here in a second. Couple points though. I don't think either one of these litigations is going to directly impact employers that have health plans. It's not like they're J&J or AbbVie are going to come after you next. Second, I don't think they're going to come after participants. So I think arguably what is going to happen is it's going to the extent that J&J or AbbVie or any other manufacturer is successful, it's going to change either the feasibility of these accumulator programs or how they operate. The third lawsuit, which I got a question, was HIV and Hepatitis Policy Institute versus the Department of Labor. For those of you that have been paying attention, back in 2020, HHS published a rule that said you can't exclude copay assistance from the out-of-pocket maximum under the ACA for a drug unless there is a suitable generic available. The problem was is that directly contradicted qualified high deductible health plans, which the IRS has previously said, hey, you can't include, especially for purposes of the deductible and out-of-pocket maximum, copay assistance under high deductible health plan and still have to be a qualified high deductible health plan. So HHS rules, at least for high deductible health plans, arguably outside of generic drugs, would have disqualified an HDHP from being a qualified HDHP. So HHS issued some temporary relief from that, and then when the 2020 rule, they changed course and said you're allowed to. You basically gave plan sponsors the chance and said you can either count it against out-of-pocket maximums or you can exclude it. Doesn't matter if there's generic available. Well, HIV and Hepatitis Policy Institute sues them and says there's no basis for this rule. They sue them in district court in the District of Columbia. They're successful. The court vacates the rule, and in their initial decision it says, hey, HHS, in a footnote, it says, HHS, if you have any questions about how this vacated rule is now, what rule is in effect, petition the court. So they petition the court. HIV and Hepatitis Policy Institute files another brief. And just a couple weeks ago, the court issued another one that says the 2020 rule is vacated. But in the meantime, HHS had issued an enforcement policy decision that said, we're not going to enforce the rules under the 2020 rule until we've had a chance to validate this and possibly issue another rule. So the court's decision says, yes, 2020 rule is vacated. So the rule in place is the 2020 rule that says you can only exclude copay assistance from the out-of-pocket maximum if there's a suitable generic available. But HHS says we're not going to enforce that requirement, and the court said we're not going to upset the apple cart, and we can't force. This decision has nothing to do with the HHS's non-enforcement policy. So what does that all mean? It means right now, stay the course. Don't make changes based on this. Monitor this closely. We are monitoring this as well. And it also depends on what service provider you're using. Savon, for example, adopts a benchmark state. Again, I think that's Utah, and says able to move all of these drugs that are on their list to non-essential health benefits. Well, remember, this HHS rule only applies what counts for purposes of the ACA out-of-pocket maximum, which doesn't apply to non-essential health benefits. So frankly, to the extent that your drugs on this list are non-essential health benefits, this HIV and Hepatitis Policy Institute decision has no impact. It only has impact on those drugs that are included in these programs that are still considered to be essential health benefits. But again, because of this non-enforcement policy by HHS, I don't suggest changing any way your accumulator programs are working today. Monitor it. We'll be on top of this and be prepared that we may have to make some changes even mid-year, depending on what HHS does. Moving on, a couple more topics. I'm going a little bit long. I'm sorry. I tried to have you out of here in a half hour. I guess I'm going to go to an hour. My apologies. Regulatory activity. You know, when administrations change, I'm not saying it's going to happen, but the kind of the first act of the new administration is they actually send their chief of staff, I believe has a lunch with all of the people in charge of the entire administrative, the secretaries of labor, and the people that are acting in those, and they pass around this letter that says that a president has, and this happens literally on inauguration day, has has stopped every regulatory activity that's currently ongoing. So if you haven't issued any, pause it. If you've issued some, but there still can be pulled back, pull them back, which is why, when the change from the Trump administration to the Biden administration, you saw a bunch of agencies rushing to put out final regulations, particularly that had to do with, on the retirement in the benefits world, it was more on the retirement side, ESG regulations, considering ESG factors, with respect to your fiduciary responsibilities and investments. Voting proxy rules, those were pushed out at the very last minute, in late December, to try to get those out where they couldn't be touched by the new administration. So what are the proposed rules that are kind of lingering out there? Mental health parity. That's the key one. I guarantee you, even though the proposed ones, maybe I shouldn't say guarantee, I am highly predict that even though the proposed regulations under mental health parity were issued in July of last year, the final ones will be coming this year. HIPAA privacy rule regulations, which we're going to touch on a little bit later of our last topic. I fully suspect that there's a couple different proposed rules lingering out there. Most recently has to do with reproductive rights, and in light of Roe versus Wade being overturned, I think we're going to see those be finalized this year. Last, ambulance reporting. There's this ambulance reporting requirement that currently is in effect. There's a DOL delay because they got to figure out how this works. It's really only a 2-year requirement. It's probably going to be a lot like the RxDC reporting requirement, where not only air ambulance providers need to do the reporting, but health plans need to do the providing. Just keep in mind, I am less sure that we'll see those issued this year. I think that's much less importance. And lastly, again, I mentioned there's HIPAA changes. So this is just, again, it's both with respect to reproductive health, which is going to change. Right now, covered entities are allowed to turn over reproductive PHI that deals with reproductive information without authorization. It's permitted by HIPAA. They're not required. HIPAA's privacy rule is going to be amended to actually prevent that information from being turned over upon investigations unless authorized by the individual. I think the idea of this is HHS is worried that in some states that have severely limited abortion, if a resident goes to out of state to get an abortion, and an investigation ensues, this is going to protect the provider from having to turn over information to those investigators. So I think that's high on the priority list. So I think we'll see those changes. There are also some proposed rules, amending the privacy rule with respect to coordinated care. So why is this important? I think this is going to require some changes to your HIPAA policies and procedures, especially for those of you that have employer self-funded plans. Very likely if you're a business associate to self-funded plans. And since it's been about 10 years, because the last time HIPAA regulations were issued were in 2013, since we updated our HIPAA kit. Once these are finalized, I will be updating the kit. I think they're going to look substantially different. My goal is to make them easier to use than what we currently have, but keep your eyes and ears open for that. We will publicize that pretty significantly when it's done. But if you have any questions in the meantime, please let me know. And with that, I've kept you long enough. I apologize. If you have any questions, I'll hang on the line here for a minute or two. And if not, have a great rest of the week, and hopefully you stay warm.